Thank you for inviting me. It's an interesting debate today, a different kind of perspective, and now it's a turn of a perspective of the Council of Europe. But I want to start from the point that was highlighted in the previous presentation, and about the quotation of this book at the end of the 70s. The end of the 70s are quite close to the period in which we live nowadays. Because at the end of the 70s, we had the first wave of use of computer, at that time mainframe computer. And for this reason, at that moment, the people realized that they are not able to control the information that were no longer on paper, but became digital information. In the big data, we are in the same situation, because like in the past, we are not able to understand the process that are ongoing and that are realized using big data analytics. So in this sense, there are three different periods: the 70s, the 80s, 90s, and nowadays. But only in the 80s and 90s we were in a position in which we are able to understand what was the purpose of data collection and to manage this purpose through traditional instruments like the consent. Right now we are like at the beginning, and for this reason we have the same concern. The idea not to have the control over information. The idea not to be able to understand the purpose or the way in which information are used and the way in which information are managed. In this sense, the Council of Europe in the 70s suggests, through the guidelines that then became the Convention 108, suggests new new manners to address the kind of issues. And as pointed out, this suggestion became part of the common culture in the field of data protection. In this sense, right now the Council of Europe, through these guidelines, for instance, of big data, try to go forward to define a scenario that is different from the scenario that is described in the GDPR. Try to find some solution that are more challenging, if you want, but that tend to put forward the threshold in order to have a system, a regulatory system, that is able to give a sort of answer to the main issues that the big data poses and that in many cases are not easy to be addressed on the basis of the GDPR. So this is the context. So the GDPR offers a certain kind of manner to address the issues related to data protection, and mainly is not focused on new issues like big data. There are no specific provision, and moreover there is a traditional approach for some aspect that is based on the purpose specification at the moment of the collection of personal information, that is based on the emphasis on the consent of the data subject, that is not so in line with what happens in many cases when we use big data analytics. In this sense, the guidelines on the big data adopted by the Council of Europe have two different potential positive aspects. Inside the European area, have the chance to suggest a different kind of approach, a different manner to address this kind of issues posed by the new technology. And outside the European context, as mentioned before, the European Union is focused on a specific territorial scope, a territorial area, and in the case of Council of Europe, we have a broader approach. And this broader approach leads us to put together regulatory systems that are quite different. For this reason, the approach is focused on the principle. It's a regulation that does not go into details like the GDPR, but focus on main principle. As a consequence, this different approach, principle-based approach, has more chance to address the issues posed by the change of technology. Because sometimes we have the idea, the feeling that some provisions of the GDPR are very detailed, and it will be not so easy that so detailed provision works in the next 10 years, for instance. The approach of the Council of Europe is different, necessarily different, because this is not an international organization like the European Union with a specific territorial structure, and also with the same power in terms of international relationship among the members. But from this perspective, it's interesting pointing out that this principle-based approach may be a different way to address the issues related to privacy and data protection in the context of new technology. So focusing on the guidelines move from the right to privacy and the right to dignity of individuals that are recognized in the Convention 108. The Convention 108, as I mentioned, was written in 1981. For this reason, it is a very traditional convention, if you want. So it's based on the idea that you, as a data subject, have the control over your personal information. But as you know, in the big data context, it's very difficult to say that you have the control, because the control is based on the fact that you know the manner in which your information are used, you know the purpose, and the purpose do not change when the data are used, reused, and through the different stage of analysis. So in this sense, the suggestion was to contextualize this principle of the Convention 108 and contextualize this idea of right to control in the specific present situation of the massive use of data and of big data analytics. In this sense, there are different kind of issues that are taken into account by the guidelines. There are some provision in terms of privacy by design. For instance, we suggest to have a sort of simulation in order to test which is the potential impact of the use of data when you use algorithms before using algorithms on a large scale. There are some solutions about the consent. Again, in the consent, we suggest to have a user-friendly solution in order to give the chance to the data subject to object against unfair use of their information. And we suggest also to have a sort of simulation of the effect of the consent provided by the data subject and so on. We have some specific provision on anonymization. For instance, we suggest to assess the risk of re-identification, and other provision on fields that are not core in some debate about data protection. For instance, open data. There is a specific provision on open data that suggests to take into account the effect of open data strategies, because in many cases we focus on a specific data set. We open this data set without taking into account the fact that this data set can be merged with other data sets, and the fact in terms of risk for privacy might be relevant. And there is a final provision also on education. But the main issues that is addressed by the guidelines is related to the risk of the use of data. Because when we talk about big data, we talk about a way to use data in order to extract further information, and to extract further information mainly to take decision. So big data analytics are used as a supportive decision method. And in this sense, when we take decision using big data analytics, in many cases we don't focus on a specific person, but we focus on groups. In some cases, we don't know the specific identity of the member of these groups, but we know that people belong from a specific group. And we apply some features, we take some decision about that person that are part of the group. And in this sense, the guidelines suggest to move from the individual dimension, that is the traditional dimension of privacy data protection, towards the collective dimension of data protection. Because what is important in many cases is not how the decision affects the specific person that can agree or not with the outcome of the big data analytics process, but in many cases is the risk in terms of societal impact of the decision adopted on the basis of big data analytics. How this decision may discriminate one group or another group, or create inequality, and so on. And in this sense, we have on the border of the traditional idea of privacy and data protection, and there are many overlapping with very close topics like the ethical and the social dimension of the use of data. And in this sense, the core element of the GDPR is represented by the impact assessment. But this impact assessment is a multiple impact assessment because taking into account also the ethical and the social impact of the use of data. So the idea is that we have to shift from the individual control that doesn't work so well in the big data context, where you are not able to control your data, and move towards a situation in which we have a form of risk assessment that reduce, since the origin, the potential negative outcome for the individual and for society of the use of data. And this is something in the debate in the first part of the day today in this line. So it is very difficult to put on the shoulder of an individual the decision about the use of data in the big data context. It's like asking you if you trust in your car when you use the car. You are not able to check all the parts of the car, but there is someone, there is an authority, there is a specific entity that check for you the level of the risk, if this level of the risk is acceptable or not. And this is the idea that we use partially in the guidelines, the idea that the individual should be aware about the risk related to the use of data, and this risk should be assessed. And then when we talk about risk, we consider not the risk only focused on privacy and data security, for instance, but a broader idea of risk, because the big data may have impact on different kind of issues, mainly related to ethics and social outcomes. In this sense, we suggest to have a precautionary approach in the use of big data and to adopt the policies that prevent this kind of risk. And we suggest to move from data protection impact assessment towards a privacy, ethical, and social impact assessment. There are few countries in which already exists something like that, in which the privacy impact assessment is adopted in a broader sense, and that takes also into account the ethical and social dimension, but there are very few cases. In this sense, we suggest to have an assessment that takes into account also the ethical and the social implication. Obviously, the main problem is which is the benchmark, how you set the level in terms of values, of ethical and social values that you want to protect or take into account in your assessment. And this is a very tricky point, because when you make assessment, you have to have something to compare. And the solution was found in a model that is based on 3 different layers. The first layer is represented by the values recognized by international charts of human rights and fundamental rights. In that chart, we find the values that are commonly accepted by all the members of the Council of Europe. And in this sense, they provide a general paradigm in terms of values that we should take into account in the assessment. Another level is represented by the peculiar contexts that exist in different areas, in different national contexts. Obviously, when we talk about value, when we talk about social dimension, these are different in different parts of Europe or also outside of Europe. When we talk about privacy in terms of security, security is always the same because it's mainly a technical issues. When we talk about value, the value can be common value, but we may have a different kind of nuances of this value in different countries. So the second layer is represented by the perception, the way in which these values are described in the single specific area. But when you want to apply this kind of assessment with regard to a specific solution that you want to develop in the field of big data, you have to take into account the specific nature of the product or the process that you want to adopt. In this sense, we need to have a more into details analysis. And the suggestion in the guidelines is to adopt ethical committees that have the task to evaluate in the specific case with a specific process which is the potential impact of the process on the ethical and social dimension. So there are three different levels that move from the very general context of the Charter of Fundamental Rights and right to the last more into detail analysis with regard to specific application and how it impacts on the use of data. All this, like in different kind of impact assessment, when we talk about not only data protection impact assessment, but impact assessment in the context of technology development, should be adopted not only inside of the company, inside of the entity, but should be based on a sort of engagement of the different stakeholders that are potentially affected by the use of data. And so we suggest a collective dimension and also a participative approach in terms of conducting this assessment. And we think that the Data Protection Authority may play a relevant role in this sense. Obviously, all this framework is not an easy framework, is a challenge, but when in 1981 the Convention 108 was adopted, was the first convention at the European level and the PICA scenario that was new at that moment. And if we think that data are the so-called new oil, the data are so important, so relevant, we think that we have also considered that if they are so important, they have to be have been used in a manner that is compliant with the fundamental value. So the fundamental values are very important and should be protected over the interest of the economic interest or specific perspective adopted by each company. So if we move from a value perspective, we have to consider that also the effort required by this model can be justified in the light of the fundamental nature of the right of privacy and data protection.